My name is Vartan Manukian and I'm a practicing paralegal in Toronto, Ontario, Canada. This is video number 4 and is entitled Opening the Legal File. You should open a legal file even if you're not retained in order to avoid the specter of a phantom client. This is a person who drifts in and out of your office, makes numerous phone calls, has brief conversations with you, and then disappears. Although you follow up the meeting and the telephone conversations with a letter, you do not receive a response to it until he reappears at a time when you're not expecting him and alleges that you missed a court date or a limitation period in a civil case. Such an allegation will no doubt give rise to a claim with your insurer. A good way to avoid this situation is to have the person sign a document in the office at the first meeting saying that you're not retained to represent him until you receive written instructions or a monetary retainer. In a civil case, advise the person that another paralegal should be consulted immediately because of the limitation time period involved. Keep a copy of the non-engagement letter, setting out clearly the conversation you had with the person, and make a note that there is no doubt in the person's mind that you're not retained to represent him, and that if there's any disagreement with the contents of the non-engagement letter, he or she agrees to respond to you immediately after receiving it. After the initial interview with your client, you will begin to put the defense case together by gathering the evidentiary building blocks. Make use of subfolders in the legal file which help organize it. You do not want to be shuffling through your legal file in the middle of a trial or submission looking for a document. Loose documents should be fastened to the legal folder, as there is nothing more embarrassing than dropping your client's file and having everyone look at its contents. Arrange all documents chronologically and number them sequentially. When you receive information from your client, you should investigate it for several reasons. First, as a licensed practitioner, you have an obligation to make sure that all documents provided to the court or to the opposing side is verified for accuracy. Second, it enables you to consider whether you should advise your client to resolve the charge, settle the case, or proceed to trial. Third, it strengthens your resolution discussions, as the opposing side will know that you're well prepared for the case. As mentioned in an earlier video, the hallmark of a good advocate is meticulous preparation. In addition to your client providing information, you should obtain disclosure from the prosecution as early as possible. The disclosure is sometimes only available on the first appearance date in court. Remember, your client is entitled to disclosure, but the prosecution's obligation to disclose is triggered only when a request is made for it. The disclosure helps your client understand the case he has to meet, as it is the duty of the prosecution to prove all of the essential elements of an offense beyond a reasonable doubt. We will be discussing disclosure in greater detail in later videos. For now, know that disclosure can be ordered from the prosecution, sometimes referred to as first-party disclosure, or from a third-party source, sometimes referred to as third-party disclosure. I'm always concerned when I hear that certain prosecution officers, in their insatiable appetite to move cases along, engage in resolution discussions without themselves having disclosure, and therefore not knowing if they can prove the case beyond a reasonable doubt. This approach takes an added significance in case of unrepresented defendants. More on this topic later on in the series. So remember, as you gather physical evidence, make sure that you verify and check for accuracy any documentary evidence you intend to provide to the court or the opposing side in support of your client's defense.